Contract Law 1 course at the University of the West Indies, Faculty of Law at Cave Hill. Today's lecture is on the Doctrine of Privity. Here's a brief overview of the lecture. We'll start off with an introduction to the Doctrine of Privity. We'll then look at the Doctrine of Privity in some more detail, including all the cases that come with it. Then we'll move on to the exceptions, and lastly, I'll provide a brief summary. The Doctrine of Privity, in a nutshell, means that only parties to a contract can be sued or can sue upon it. In other words, if you're not a party to the contract, you cannot enforce it. Neither can you be forced to do something. Now, there's some resemblance with the notion of consideration. Recall that only a person who provides consideration is able to sue upon a contract. However, the Doctrine of Privity is more far-reaching. In fact, it consists of two separate rules. The first rule, which is widely accepted and has been widely accepted throughout the history of contract law, is that when you form a contract, you cannot impose obligations on third parties. So parties A and B forming a contract can only impose obligations on each other, not on third parties. This is fairly obvious and not controversial. Indeed, we'll find that there's only really one minor exception to this part of the Doctrine of Privity. The second part is somewhat more controversial. What the second part entails is that parties to a contract cannot confer rights to third parties. So party A and B cannot get together and confer rights to another party altogether. Let's call them party C. Now, this part of the rule has not always been accepted. Indeed, before the 19th century, it was accepted that party A and B could come together and form a contract which would be to the benefit of a third party, party C. Our case here is Bourne and Mason. In this case, it was a doctor and a patient, and the patient promised the doctor that if the doctor healed him, he would give the doctor's daughter some money. Now, of course, the doctor's daughter was not privy to that contract because that contract was between the patient and the doctor. However, the court held that that promise was enforceable. So that used to be the rule on privity with respect to conferring rights to third parties. In other words, that was possible. However, the law evolved, and by the 19th century, it was usually no longer possible for parties A and B to conclude a contract for the benefit of party C. In other words, the Doctrine of Privity was evolving, and the second rule of the Doctrine of Privity was becoming entrenched. Now, a good case to illustrate this is Winterbottom and Wright. What happened in Winterbottom and Wright was that there were three parties. There was the owner of a carriage, there was the driver of a carriage, and then there was the mechanic who was looking after the carriage. Now, the owner of the carriage had a contract with the mechanic. One day, the driver went out with the carriage, and because the carriage broke down due to shoddy work by the mechanic, the driver got injured. The question arose whether the driver could sue the mechanic in contract. The court held that he could not, because the driver was not a party to the contract between the owner of the carriage and the mechanic. Thus, the driver was left without a remedy. The second rule of the Doctrine of Privity, specifically that you cannot confer benefits to third parties, was firmly established and entrenched in the case of Tweddle and Atkinson. What happened in that case was that there were two fathers and a son and a daughter. Now, the two fathers, being a father and a father-in-law, promised that upon the marriage of the son and the daughter, the father, as well as the father-in-law, that means the father of the daughter, would give the son money. Now, unfortunately, before the father-in-law could hand over the money, the father-in-law died. Now, the executors of the father-in-law's estate refused to give the son money. Normally, that would not be a problem because, of course, normally the father of the son, assuming he was still alive, could sue the estate of the deceased, of the father-in-law, and claim under the contract that the estate had to pay the son the amount of money as agreed. Unfortunately, the father of the son also died. So the only person who could have sued upon that contract also died, and therefore the son was the only one left who might have sued. But in Tweddle Atkinson, the court confirmed that since the son was not a party to the contract, notwithstanding that it was agreed to his benefit, the son was not able to sue upon the contract. Let's have a look at how the court put it. Some of the old decisions appear to support the proposition that a stranger to the consideration of a contract may maintain an action upon it, if he stands in such a near relationship to the party from whom the consideration proceeds that he may be considered a party to the consideration. But there is no modern case in which the proposition has been supported. On the contrary, it is now established that no stranger to the consideration can take advantage of a contract, although made for his benefit. Tweddle and Atkinson was a decision of the High Court. Some years later, the House of Lords had an opportunity to either reject or endorse the view which was espoused in Tweddle and Atkinson. And in fact, the House of Lords fully endorsed the view taken in Tweddle and Atkinson, namely that a party who was not part of a contract, not a party to the agreement, was not able to sue upon it. In other words, the second rule of privity was endorsed by the House of Lords, and this happened in the case of Dunlop Pneumatic Tire and Selfridge. Now, this case involved a minimum price agreement between Dunlop and another firm called Dews. And Dunlop would sell its tires to Dews, and Dews was acting as a type of wholesaler, and Dews promised that they would not sell the tires below a certain minimum price. Now, Dunlop also demanded and got a promise from Dews that if Dews sold on the tires to another party, they would extract the same promise. So what happened was that Dews then sold on tires to another party called Selfridge. And Dews and Selfridge had a similar contract whereby Selfridge was not allowed to sell the tires under a certain minimum price. Now, what happened was that Selfridge did sell under that minimum price, and so they were sued by Dunlop. But of course, Dunlop was not a party to the contract between Dews and Selfridge, so they could not sue upon it. And this is what the House of Lords agreed with. In fact, not only does Dunlop Pneumatic Tire and Selfridge confirm the second rule, it also confirms the first rule of privity, which is that you cannot impose obligations on third parties. In other words, the contract between Dunlop and Dews could not impose an obligation on Selfridge, just as much as Dunlop was not able to derive a benefit from the contract between Dews and Selfridge. One of the upshots of all this was the development of the Neighbour principle in tort. You'll recall from tort that there's the famous case of Donahue and Stevenson, where Miss Donahue went and had a ginger beer in Glasgow in Scotland, and unfortunately the ginger beer had a snail inside of it. And Miss Donahue then tried to sue Mr. Stevenson, who was the manufacturer of the ginger beer. Now, the court held that, of course, there was no contract between Miss Donahue and the manufacturer, because the manufacturer had in fact sold the ginger beer to the cafe in which Miss Donahue had consumed her ginger beer. So Miss Donahue had a contract between herself and the cafe had a contract between themselves and the manufacturer, Stevenson. However, the court overcame this difficulty by developing this notion of the neighbor principle. So, as a result of the doctrine of privity, and which sometimes, of course, as we saw in Winterbottom and Wright, can lead to unfairness where someone is not able to sue, the courts developed the law of tort to fill that gap. The doctrine of privity is fully recognized in the Commonwealth Caribbean. As an example, we can look at a case from Grenada involving Isa Nicholas and Electrotech Services. This case went all the way to the Privy Council. What happened in this case was that Isa Nicholas were the owners of the Ramada Hotel in Grenada. They had contracted with someone to refurbish and renovate their hotel. In turn, their contractor had subcontracted with Electrotech to deal with some of the electrical installations. When the contractor did not pay Electrotech, Electrotech tried to sue the owners, ISA, directly. So again, we have this scenario where there are essentially two contracts. First of all, the one between ISA and the contractor, and then secondly, the one between the contractor and the subcontractor, Electrotech. The question again arose whether Electrotech, as a third party to the contract between ISA and the contractor, was able to sue. And the court held that they were not able to sue, notwithstanding their argument that there had been some direct contact between Electrotech and ISA Nicholas. Now, this may sound very problematic. However, as we've seen, obviously, Tort has filled the gap through the Neighbour principle, but there's also other ways of avoiding the impact of the Doctrine of Privity. For instance, where the case of ISA Nicholas, as an example, is concerned, what could be done is that the contracts could state. So for instance, the contract between ISA Nicholas and the contractor could have stated that subcontractors, in case they weren't paid by the contractor, would be paid by ISA Nicholas. Now, this involves something called agency, which we'll come back to later, where someone acts as someone's agent, and that then allows the third party to sue in certain circumstances. We'll come back to that later. But generally, let's just note that the Doctrine of Privity is not stubborn in the sense that it cannot be overcome. By clever drafting, by thinking about it beforehand, we are able to overcome it. Just as, for instance, when we talked about acceptance and we talked about the postal rule, and many people think that's unfair. Well, the postal rule is what it is, but it is easily overcome by drafting your contract appropriately. Now, what we also note is that the Doctrine of Privity has been loosened in part. For instance, in the case of Trident General Insurance and McNeice Brothers, there was again a situation where Trident General Insurance had a contract with a main contractor who was not a party to this case. So that was the first contract. Then there was a contract between the main contractor and McNeice Brothers, who were the subcontractors. Now, someone from McNeice Brothers got hurt and tried to sue the insurance company for compensation. The problem, of course, once again, was that the contract was between the insurance company and the main contractor, not between the insurance company and the subcontractor. However, here the courts loosened the rule to allow the subcontractor to claim from the insurance company. And the argument made by the courts was that this third party, this subcontractor, was in the contemplation of the parties at the time of concluding their agreement. That means when the insurance company concluded their agreement with the main contractor, they would have been aware that there would be third parties, subcontractors such as McNeice, who would also be working at that construction site, at that project site, and that they would also be covered. Now, one could argue that this exception or this loosening only applies to the insurance scenario, and to an extent it probably does. But we'll see that in some other cases, third parties have also been able to penetrate the Doctrine of Privity.